Welcome to the SSI Orbit podcast, a forum for conversations that explore the ever-growing ecosystems of self-sovereign identity. And I'm your host, Mathieu Glaude. Today I talk with Chetan Pull, a fellow colleague of mine from the Toronto blockchain scene. Chetan is a technology and data management lawyer at Deloitte Legal. His experience includes complex multidisciplinary mandates in privacy, cybersecurity, blockchain, cryptocurrency, technology audits, and more. Chetan has many publications under his name, including a book called Big Data Law in Canada, which we'll include in the show notes. Now, in this conversation, we break down privacy from a legal perspective. We talk about how entrepreneurs need to look at complying with global data privacy laws when launching software globally. We talk about the history of data privacy laws and look at laws like GDPR. We talk about the right of erasure's effect on data ownership and control, and also the right of erasure's effect on data stored on immutable blockchain ledgers. We talk about if data privacy laws will get more complex than they are today. We talk about pseudonymity, decentralized protocols. All to say, this was an awesome conversation with lots of good material, and I hope you'll enjoy it as much as I did. Now, without any further ado, here's my conversation with Chetan. Enjoy. I think the whole area of consent is interesting and probably rapidly evolving globally. I always, it's funny, like I really enjoy personally the TV show South Park. I don't know if you've ever watched watched that. Like I felt like they do a good job at keeping up with commentary, and like it hasn't deteriorated. Like I still very much enjoy it, but there was a particular episode of South Park. Oh gosh, it might be close to 10 years ago now. I can't really remember when, but it was a whole joke around one of the characters consenting something to Apple without having read the terms and conditions of what they were consenting to, and then they went into this whole stupid thing. But it was funny.
Ahead of its time.
Yeah. There's a lot of conversation in the digital ID space about that, and digital ID kind of helping solve some problems to do with consent and kind of, I guess, two-sided consent. Mm-hmm. The way I look at privacy typically, and the way I talk about privacy to folks is like consent is one piece. I talk about transparency as well. Are these kind of the two main buckets of privacy? Like how do you, it's probably a pretty broad question, and I don't know if it's just from a legal lens or an overall lens, but how do you look at privacy?
Yeah, privacy is a very broad concept in the law. And I think it's, as time goes on, we're categorizing certain parts of privacy, and sometimes even taking out those categories and making them independent areas of law. And I'll give you an example. So my understanding of privacy, very broadly speaking, encompasses security, data protection. That's one traditional branch. Another branch is personal information collection, use, and disclosure. And a third branch involves a bunch of use cases for personal information or use cases for confidential information in artificial intelligence and competition law. And so those are the three main, I may even be forgetting one or two, but those are the three main areas of privacy. And for authentication and digital ID, I see that as growing out of the concern for security and data protection. And meanwhile, AI regulation, that's becoming more likely, particularly given the latest proposals coming out of Europe. And so it might be that AI regulation will no longer be regulated solely by the use and procurement of training data. It might be regulated completely independently as its own area of law. So I hope that provides a nutshell definition of what privacy is and how it's evolving.
And would you say, so from your breakdown, it's digital ID kind of falls within the first bucket of the security data protection. The way I look at digital identity is it's kind of core to all of the different business functions that happen. And especially if you're creating these user-centric experiences, there could be elements of security, data protection, but there's also elements of if me sharing credentials or PII, and just how my PII is being used downstream as well. I guess those are the three buckets that you kind of described under privacy.
Yes, and while I was being put on the spot, I actually neglected to mention a fourth bucket, which is commercial use of data in general, which would require consent and generally deals with emailing and commercial electronic messages and that sort of thing. So I think I'm going to expand the three buckets that I referenced before into four.
We got a new one.
Yeah.
Do the same data privacy laws kind of govern these? Like, do these four buckets, are they all encompassed within kind of single data privacy laws? Like,
not really. And it differs from jurisdiction to jurisdiction. So at the present time in Europe, for example, we have GDPR, and GDPR is applicable across the EU. But as I understand it, there are exceptions in certain member states with respect to certain spheres of regulation. Similarly, in the US, they have, it's just a jurisdictional mess as far as I'm concerned, insofar as the sphere of regulation and who gets to decide the answer to a particular legal question in terms of the level of government. So there's a jurisdictional grab bag, I'd like to think, in the US. Meanwhile, in Canada, it's the same but different. We've got a federal regulator for both the private sector and the public sector, but there are provincial flavors depending on what type of activity you're talking about and what industry you're talking about, be it financial or health or miscellaneous private industry. So all of that is to say that there's no one single applicable privacy law for the world. That would be an idyllic dream, but we're not there yet.
As an entrepreneur, if you're building, and a lot of, I guess, software businesses today don't have legal jurisdiction boundaries when you could scale usage in communities globally. So the idea is, depending on where your product is being used, you need to be in a position of compliance with whatever local or jurisdictional data privacy laws are in place.
Yes, and look, there's a difference between what the law is and what might apply to any particular venture, and the enforcement mechanisms available to regulators to enforce their laws that may apply. So, on the one hand, ventures on the internet will be subject globally to a variety of different regulators. As a practical matter, they probably aren't hiring counsel in every single jurisdiction in the world for compliance purposes. Most likely, they're hiring counsel in a jurisdiction that has a very high threshold for compliance, and they're trying to maintain compliance in that jurisdiction and hope that meets the standard in other jurisdictions as well. Now, as the privacy landscapes develop from jurisdiction to jurisdiction, and there are differences in how certain jurisdictions handle certain issues, I think the compliance endeavor is going to get harder and harder. But that being said, the world is gradually moving in a place where there's an increased understanding that compliance with privacy law is important. But what that means from place to place is still not exactly clear.
Are there certain data privacy laws that are kind of, I think people often refer to the GDPR as kind of having the most advanced or the tightest criteria or whatever it is? Like, I think GDPR seems to set the tone for the rest of the world. What was so I guess what's the history of the GDPR, and why has GDPR in the past years just become kind of the staple that it seems like the rest of the world is following? So some places are more behind than others, but why? What were those key or core elements to the GDPR that really set it apart from whatever else was happening?
Mm-hmm. Well, the GDPR came at a time when the big data markets were proliferating globally, and there was a need um, in a jurisdiction like Europe, where privacy was previously regarded as a fundamental right, to expand what that right means. If it's to have any force in Europe as a fundamental right, they needed a more prescriptive document as to how that right should be dealt with. That's quite in contrast to what it's been in the United States up till about last year, the year before. Privacy in the United States has largely been a matter of contract, not a fundamental right. So it's not surprising that Europe would come up with a strict privacy law prior to the United States. But as a consequence of Europe releasing the GDPR, there arose a business case for other jurisdictions enacting their own privacy laws as well, in order to have consistent global operations. Because it wouldn't make sense, practically speaking, to have one set of operations for one jurisdiction and another set of operations for another major jurisdiction. So after the GDPR came into effect, California enacted the CCPA. And then in Canada, Canada is in the middle of something called Bill C11, and we're in the middle of drafting something called CPPA, to be distinguished from CCPA in California. We've also got provincial laws coming out in Ontario and Quebec, and all of that is piggybacking off of the initial effort of Europe to push privacy law ahead globally. And I can keep talking about this, ad nauseum, but I'll just say that Europe is pushing the bar forward for so many areas of digital regulation, not just privacy. In the last year, they've issued they've issued proposals for Digital Services Act, Digital Markets Act. They've issued a proposal for Digital ID Framework. They've issued a proposal for an AI Act. And all of this, I suspect, will proliferate globally into California and perhaps the rest of the US, but more certainly in and throughout Canada.
What necessarily does the right of erasure mean? I think people have different understandings of that, but does it really put us in a space where if I am interacting with an organization or an entity that is complying under a GDPR or CPPA or CCPA,
Mm-hmm.
The right of erasure, does that really mean that the data that an organization has on behalf of me, they don't have ownership of this anymore? If I can just go to them and ask for data to be deleted or commercial use of it to stop, or whatever these buckets are, does it really mean we're moving to a space where data ownership is fundamentally changing?
That's a very good question, because there are two sets of rights here. There's the question of who owns the data, certainly, but there's also the question of what rights the data subject has in respect of data, whether or not it's owned by the data subject or some other large entity. And so the right of erasure, which is still, by the way, being sorted out and determined, is primarily getting at the data subject's right to control what information about him or herself is presented publicly, so is freely disclosed, and whether that data subject can insist on the removal of that information in a public sphere, or can insist on the deletion of that data, one or the other. And so in Canada, we're actually not sure yet. There was a very recent reference in the federal court that determined that Google is subject to our federal privacy law, PIPEDA, and that when it lists information in its search algorithm, it's not doing so for a journalistic purpose. So it is subject to the privacy law. Now, does that mean that there's a right of erasure in Canada? We still don't know. And perhaps more to the point, even if there is a right of erasure in Canada, what does that mean for enforceability outside of Canada? After all, Google's main headquarters are not here in Canada. They're in the US. And there's precedent for Google appealing to rights in US law to not have to obey Canadian court orders to delist search records. So the exact content of the right of erasure per jurisdiction, I believe, is still in consideration. And perhaps more to the point, the question of enforceability, that is still in flux, and we have no idea yet how to deal with that, given that we're essentially trying to regulate per jurisdiction a technology that refuses to be kept within the bounds of any jurisdiction.
It seems like it's getting more and more complicated, where technologies enabling multi-jurisdictional or actually like borderless use. Been talking a lot lately about decentralized autonomous organizations, which when you have all these pieces coming together with crypto and credentialing pieces, and the whole remote work and work from home, all these pieces come together to make it possible now to offer new mechanisms of coordination for work or to achieve certain goals without necessarily having any reliance whatsoever on physical location. Do you think it's going to keep becoming, this is kind of like a future question, if you're looking out like 10 years from now, is it just going to keep getting more complex on a global landscape because there is kind of jurisdictional boundaries when it comes to this stuff, or is it going to get easier at some point?
Well, we're definitely in a phase of growing pains, but if I'm being asked now to look way into the future, I suspect that we'll have to reconcile the problem we have of trying to locally regulate technology that doesn't operate only locally. And so what I suspect will ultimately happen, whether it happens in the next 5 years or 10 years, is we'll have an international body that will oversee international regulation of the internet. Now, I know how crazy that sounds because every jurisdiction has their own legal traditions that they are particularly attached to. Like, for example, in the United States, they have the right to free speech, which is different from the right to free speech in Canada, for example. So the question of how we're going to have global regulation and how that will work per jurisdiction, I think that's something we'll have to wrestle with. But ultimately, I do think that we're going to have some form of global regulation. And in fact, we already see that to a smaller extent in Europe. After all, the European Union is a collection of member states, but we have to remember that they are all separate countries. And to the extent that they have a GDPR and various other acts that are proposing to regulate various spheres of big data, suggests that they may be a model for how international regulation of big data will ultimately work.
This does exist in other areas, right? Like what one we've heard often over the past year and a half with this COVID stuff, like the World Health Organization is a global regulatory body. So it's the idea, and I've thought about this a bunch too, when maybe a little unrelated to data privacy laws, but just the power you're seeing, and I know you think a lot about this stuff too and have opinions on it. the power you see big tech companies have to make decisions have tremendous downstream impacts. And I think there was never a protocol or never an international body kind of in place to govern some of these things. And then you're stuck with individual private companies putting governance bodies in place to do stuff when maybe you're totally right. The thing that needs to kind of catch up to where the internet has brought us is you need to have kind of independent underlying protocols or governance bodies.
Yeah, and I think that reasoning applies beyond the internet and beyond internet technologies. We're seeing similar problems in cross-jurisdictional management of pollution, for example, and also with respect to how disease can transfer from country to country. We can try to contain things as much as possible, but ultimately there has to be an international effort to, according to a unified set of principles, to regulate material that refuses to recognize political borders.
I love the example of pollution management, because you're right. Similarly to a lot of these borderless protocols or softwares, pollution moves around. It doesn't have to go through border patrol to go from one place to another. Shifting a bit back to, I guess, going back to the right of erasure stuff. I'm sure you've spoken about this a lot over the past years, having spent a lot of time on blockchain. How do you look at the right of erasure on an immutable ledger? What are the recommendations there? Is it more of, because you can't erase data if it's on an immutable ledger. So is it just that it's not enforceable? Like, how do you look at that?
That is a wonderful question. And I've spent a lot of time pondering and worrying about it, because on the one hand, you're right, a ledger has particular utility when it's immutable, that we all see the benefits of in certain contexts. But there are cases where if PII is on that ledger, it may need to be removed, but that would be difficult to impossible if it's immutable. And I'll give you an example most recently in the digital ID space. According to the EU's digital ID framework that's been proposed, ledgers are stated to be admissible as evidence and recognized for their immutable nature. Now, I'm not yet sure how to reconcile that with the GDPR, except when there's some mandate for anonymizing what gets put on the ledger, and being reasonably sure that it can't be reverse engineered to identify a person. And I think that might be either more of a technical question, or at least an area where the lawyers are going to have to get in the same room with the technologists to figure out how this area works.
Yeah, even in the self-sovereign identity architecture that does leverage distributed ledger technology or blockchain as a public identity utility. So all that means is just simplifying this, but you're storing information related to issuers of credentials, because when a credential issuer issues a credential to another entity, and that other entity then takes that credential and uses it as a proof, whoever is verifying that proof wants to verify that the credential that is being presented to them hasn't been tampered with. They want to verify the provenance of the issuance of this credential. So they want to know that this driver's license credential that I'm being shown to open a bank account, in fact, was issued by a particular government agency that has the right to do that. Mm-hmm. In this architecture, we're storing information relating to the issuers of credentials on a blockchain. I'm even hearing conversations of people saying, like, okay, we're not storing any PII on a blockchain. That's a bad idea. We've kind of crossed that bridge some years ago, that, you know what, that's really not a good idea. But some people even look at public keys as being PII because they could be traced back.
Yeah, I mean, and we see the same basic question in the use of training data in the AI context as well. If there's some mechanism to de-identify the data in whatever form it ends up persisting in afterward, whether it's in a database for PII use or whether it's in a blockchain format, the question ultimately is, can there be some sort of reverse engineering to identify the person? And I don't know that the lawyers are going to be all that helpful here. I think this is where we really have to lean on the technologists, because while some technologists will firmly state, no, de-identified data cannot be reverse engineered, there seems to be a camp, small and growing, that yes, de-identified data in certain cases can be reverse engineered, whether we're talking about data that's written to a blockchain or used in some other context. So at that point, then you have to ask whether there's a contravention of privacy law, and that's where the lawyers will get in. But the initial conversation, I think, it's one of technology more than law.
Fair enough. So we've covered a little bit about data privacy laws here and talking about GDPR, Europe kind of ahead in the race here, and the rest of the world is following on things pertaining to data privacy. More recently, we're seeing a lot more movement in digital identity law. What's happening in that sphere? Is Europe still kind of ahead of the game on the digital ID law?
Europe is still very much ahead of the game. Just this year, it released a digital identity framework, which criticized something called EIDAS, which was the prior framework within Europe for digital ID. And the digital ID framework over there has an aim of creating a digital single market, or facilitating the digital single market. That framework also requires all member states to issue a digital ID wallet within 12 months of the framework coming into force. And it prescribes mechanisms in law, which presumably the technologists will further interpret, to ensure for proper handshaking, breach handling, cross-border recognition of technological frameworks, credential management, etc. So it's the first framework of its kind, and I think it's likely again to be adopted both in the US and Canada. More so in Canada perhaps than the US, because the US already has a US NIST framework that may form the basis for how the law is developed down there. I'm not quite sure. But the point being is that the emphasis on digital ID framework and what it means for commerce over there will surely become a use case, or it'll surely be viewed here in Canada as a model while we continue to craft our own laws. Right now in Canada, all we have in terms of legislation is PIPEDA, which will soon be overtaken by the CPPA. And those legislations reference security safeguards. Now, once the CPPA comes into effect, security safeguards will become more actionable with $25 million fines and fines of 5% global revenues on corporations and potential director and officer liability. So there will be more enforceability with respect to proper digital ID safeguards, but it's still not spelled out as thoroughly as we'd like, which is why I think Europe will be a model for Canada. And other than our legislation, we've got Government of Canada public sector directives and regulatory guidelines, which aren't particularly enforceable. We have the DIAC and Pan-Canadian Trust framework, but That's not complete and effective yet. So again, all eyes are on Europe. I've discussed a lot of our present framework in chapter 5 of my book, Big Data Law in Canada. So for anybody interested in seeing what the present digital authentication framework is, I would direct you to that source.
Yeah, and we'll put the link for your book in the show notes, so anyone interested to check it out could do so. You mentioned new forms of liability for directors. So is this kind of directors would be taking liability if they don't apply the right safeguards? Is this kind of a cybersecurity story, or what is that specifically?
It's not only a cybersecurity story. It's so directors and officers have always had the potential of incurring director and officer liability, and this liability would emerge from the duty of care and fiduciary duties, which are old duties in the common law, which have persisted over years and years, ultimately stemming from when Canada was still a colony of the UK. The duty of care and fiduciary duties, they both ask the essential question of, did the director perform up to a certain minimum standard required for a director? And as the privacy landscape matures, and we're seeing that it's easier to sue a company for not safeguarding your personal information or confidential information as it should, that's more of an indication of where the minimum threshold is for a director and an officer. And from what I'm seeing, the threshold required of director and officer is raising. And that will continue to be the case as global privacy law trends increase as well. So, to summarize, digital authentication and security safeguards in general, and privacy duties in general, are creating liabilities not only on corporations that are anticipated to be quite stiff, but they're also creating liabilities for directors and officers.
I was thinking about this earlier when we were talking about privacy, but is there a possible use of smart contracts to kind of codify some privacy or security safeguards to make it easier on folks to really have the proper guardrails in place when they're conducting business, so they don't have to think too much about it? Is that something that is a good idea or even possible?
I don't think it's an idea that cannot work. I think it's an idea that requires more legal infrastructure to work in a predictable way. There are many use cases, and there have been for some time. And from what I'm seeing, we're getting closer to the point where the frameworks are being drafted. They're not quite in place just yet. But in terms of having it as an ongoing part of a business, relying on frequent contracts and contract execution, to date, I haven't seen it in practice actually being fulfilled. But I've seen 1,000,001 projects that are being pushed ahead to try to make this happen. So I think it's a matter of time, and ultimately this will prevail. And if I recall correctly, in Vermont, and I referenced also in Europe within the digital ID framework, ledgers are presumed admissible now. So presumably that would mean that smart contracts written to a ledger or evidenced by a ledger in some form, they as well gain additional legitimacy through having the ledger presumed admissible. So little by little, we're getting in a place where smart contracts can be, and they're getting closer to what a real contract can achieve on an automated scale. But that's not to say that lawyers will be taken out of the equation anytime soon, because at any time when you have an agreement, whether it's in a smart contract or whether it's traditional, there's going to have to be consideration for very basic parts of the agreement. Like, for example, which jurisdiction's law should apply to the agreement. This is going to be important when you have a smart contract that is supported by a blockchain crossing jurisdictions. If there's a dispute later on, which jurisdiction's law will apply? And moreover, where will the dispute be heard? These are only two of the fundamental questions of contracting that smart contracts will still have to address. And you can build them into the smart contract for sure. But as the contracting issues become more complex, you're going to find that you'll want custom treatment for a lot of these issues. So I think the automation is great, and it will be great when it gets here, but legal care will still be a thing. It's not like that's going away after automation increases with contract execution.
Yeah, I think across any space, automation is probably a good thing, right? Where it allows people to just focus on more custom or more creative work. And anyways, automation, I guess downstream will breed new problems to solve for. So it's not like I think humans are good at being creative and finding creative workarounds and coming up with solutions like that. So automation just breeds more of that type of work, which I think just accelerates innovation in general.
Right. And actually, as you're speaking, I thought of yet another issue that has to be addressed in virtually every transaction that occurs with a smart contract. And that's what happens when your interface with the blockchain fails for whatever reason, be it a bug or be it, inadequate data transfer to complete a handshake or whatever. Who do you blame? And is there a way to disclaim liability somehow? These are all issues that have to be carefully considered for high value contracts.
Yeah, that's one of the things definitely I'm seeing in referring back to is basically a set of smart contracts and other stuff, but these DAOs where it's basically exactly like you said, what happens when something goes wrong? Who's taking liability for that? And a lot of the infrastructure that's in place today, the infrastructure supports that. But in these new models, when things are kind of distributed and autonomous, and a lot of the times too, in the whole blockchain space, they're anonymous or pseudonymous to some extent. Like, how do you, who's to blame for that? If people lose hundreds of millions of dollars because of a smart contract bug, then what?
Yeah. Can we now go after the developers? Because as a very common provision in developer contracts, software is sold as is with all bugs it might come with. Now there are ways to contract around that, but let's say that the common provision applies in the case of a smart contract, and the developer has completely disclaimed liability for bugs, and let's say they're successful with such a disclaimer. That potentially creates a very unjust result for somebody who has nobody to blame when they lose a pile of money due to a bug.
True. I just find it quite fascinating that in the crypto space, there's, I think we're going to keep seeing more and more of this. So just this whole pseudonymous identity movement where you have someone with just like a frog avatar and a Twitter account that is kind of responsible for executing smart contracts for tens or hundreds of millions of dollars. So it's quite funny. So and to be honest, I really don't see that slowing down. Like these protocols are just creating more and more accessibility for people to build these types of solutions. So who knows how that's going to play out, because it's kind of like running R&D tests, but on a not in an R&D lab, but on networks that have millions and millions of or billions of dollars on there.
Right, and that brings to mind another question about what happens when digital authentication technology is ready to go mainstream. At that point, will governments take a more active position and require digital authentication to the extent that everybody can be identified. And perhaps it's foreseeable that they may do this on the basis that while everybody has the right to conduct various sorts of activity online, there's a real question as to whether they can escape accountability for what they do online, right? Like, because you have the right to do something doesn't mean that you can do so with impunity. So on that basis, I'm saying there's potential for pseudonymous activity to be clamped down on by government authorities. Now, I'm perhaps thinking a little bit too far into the future, and maybe I'm thinking with a bit of a dystopian lens here, but I think it needs to be acknowledged as one of the potential outcomes of how the internet is evolving, and how digital authentication technology and laws are moving forward.
Yeah, because I guess at the end of the day, a government-backed ID or a government-issued ID is one form of identification for someone, right? That just says that I'm a legal person, and it's been kind of attested to by a certain state or province or nation state, whatever. On the online world, and with more and more digitally native interactions and business interactions happening online, there's a lot of use cases where that type of ID, that government issued ID, actually doesn't matter to what the people are trying to do. I'd much rather know that someone has a certain amount of followers on Twitter, or I'd rather know that a person has so many commits to a certain GitHub repository, or it's these identity credentials just become more than just people always go back to digitizing a driver's license or digitizing a passport. It's a lot broader than that. And I think the more and more businesses and use cases that we see online, the more and more forms of identification outside of government issued IDs become, I guess, interesting for these protocols or for these online interactions.
Yes, agreed. And as with many areas of technology and regulation, it cuts both ways, because it enables certain freedoms in the digital markets with a reasonable degree of confidence in your activities, and a reasonable degree of confidence that other people can't pretend to be you. But at the other end, there may be incentives, as I discussed before, for governments to require digital authentication where it wasn't required before. And so then there's issues of whether not having the ability to perform activities anonymously or pseudonymously is contrary to other rights, like the right to free speech, just for example.
How do you look at cybersecurity as it pertains to data privacy law and digital ID law? There's a big trend right now just in the whole technology space. It is a trend that is serving to the benefit of self-sovereign identity. It's the whole trend of like the not wanting to create new honeypots of personal information, right? Because that creates a honeypot of valuable data, and that creates incentive for breaches or hackers to go in there and gain access to that data. So there's a whole movement towards the movement of data to the edge, or the distribution of data.
I think that's a big reason that digital authentication is a concern at all. But digital authentication goes beyond just cybersecurity. It goes into confidence of the markets and the health of the markets to ensure, an easy to use digital marketplace. But traditionally, yes, digital authentication, as I view it, is a security safeguard. And I say that because the presently enforced legislation, at least here in Canada, references security safeguards. And that's traditionally where digital authentication was considered to have relevance. But when you look at the new proposed frameworks in Europe, they're going way beyond the original purposes for digital authentication. And so that's where Canada, I foresee, will eventually go as well.
Thanks for tuning in today. Hope you enjoyed the conversation as much as I did. To stay up to speed with future episodes, or to catch up on ones you may have missed, make sure to check out the SSI Orbit podcast on your favorite podcast platform, and make sure you subscribe. If you have any questions, comments, or wish to see someone in particular on a future episode, you can find me by searching Mathieu Glaude on LinkedIn or Twitter. Feel free to reach out to me directly and I'll get back to you. See you all next time.